Okay, good morning, everybody. Looks like we're ready to go, and we start this morning with a public hearing, so I will read the public hearing chair's address. This is a public hearing for proposed Regional District of Okanagan-Similkameen Bylaw number 2800.07/2022. The proposed bylaw and related information, including written comments received to date, is available for review at the head table. At this public hearing, all persons wishing to speak will be given an opportunity to do so and are asked to commence their remarks by stating their name and address. Written comments may be submitted to the head table before closure of this hearing. Anyone wishing to speak at this public hearing is asked to do one of the following. If you are participating by a computer, please click which can be found in the participants panel on the right-hand side of your computer screen. This will indicate that you wish to speak. If you are participating by a phone, press *3 on your phone's keypad. This will also indicate that you wish to speak. Sounded like my mic went off, but having indicated that you wish to speak, you will then be placed in a queue. All speakers will be restricted to a time limit of 5 minutes until everyone who wishes to speak has had an opportunity to do so. Anyone wishing to speak a second time may do so by following the same protocol of selecting the raise hand button on your computer or by pressing *3 on your phone's keypad. To submit written comments, please email them to planning@rdos.bc.ca prior to the close of this public hearing. I will now ask Shannon Duong, planner, to outline the specifics of the proposed bylaw.
Chair, I'm just going to pull up my presentation. And can everyone see this okay?
Yes.
Perfect, thank you. So this is a public hearing in relation to a proposed rezoning at 14805 89th Street. And the associated amendment bylaw is number 2800.07/2022. As I mentioned, this is a rezoning for the property at 14805 89th Street in electoral area A. The zoning that applies to this property currently is agriculture 1, and the official community plan designation of the property is agriculture. The property is entirely within the ALR and is approximately 4.97 hectares in size and currently contains a vineyard. The proposed development is to construct an agritourism accommodation building with 10 sleeping units that would be used in conjunction with the property owner's La Stella Winery, which is located directly to the south, as well as the Le Lupin Winery in electoral area C. And these would be used in conjunction with their winery tours as well as their farm operation tours. Now, their proposal also includes the registration of a statutory covenant to prohibit the construction of any agritourism accommodation units on the La Stella Winery property to the south, and that would need to be registered prior to adoption of the bylaw. With respect to the relevant permitted uses, of course, agriculture is a permitted use, and agritourism accommodation is a permitted use on this property subject to a number of criteria under section 7.3 of the zoning bylaw. And as it relates to this application specifically, this section lays out the maximum number of units, which is based on parcel size. The parcel area of 4.0 hectares to 8.0 hectares is allotted 5 agritourism accommodation sleeping units as a maximum, and this property is only 4.97 hectares in size, and therefore the proposed amendment that is being considered as part of this application is to amend the Okanagan Valley zoning bylaw by rezoning the property from agriculture 1 to agriculture 1 site specific in order to allow for that increase to allow for construction of 10 agritourism accommodation sleeping units instead of 5. And that concludes my presentation. Thank you.
Okay, thank you, Shannon. I will now declare the public hearing open at 9:06 and ask if there is anyone who wishes to speak to the proposed bylaws. I see a raised hand from Mr. Bradalenko. Please go ahead, Brad. Can you hear us, Brad?
Can now, thank you.
Go ahead.
Can I share my screen? I've got a short presentation with some images that I'd like to present.
Yeah, you've just been put on, so go ahead and share your screen.
Okay, that's easier said than done. Just trying to find where I do that. There we go. Okay, Mr. Chair, can you see my imagery?
Not yet. There, it's coming up.
There we go.
You're good to go.
Awesome. Thank you very much. Mr. Chair and board members, members of the public. Just a quick synopsis of the project. Thank you, Ms. Duong, for the good summary. A couple of additional points. Just a little bit of context. The area outlined in red is the subject property where the anticipated 10-unit project would go in the area where my hand is circling. If this is not allowed, we would be moving forward with 2 5-unit projects, one which would still be in this location, and the other would be down in this location on the La Stella property. Ms. Duong kind of went through the OCP and zoning. I'm going to gloss over that, other than just to reinforce the fact that the ALC does permit 10 units. The RDOS has taken the position to only allow 5. So from the ALR perspective, what we're doing is consistent with the ALR and the ALC requirements. So the proposal is to add a site-specific amendment to the zoning to allow 10-unit agritourism. The agritourism will be consistent with the regulations of the ALC. What we've shown here is the transportation access that would occur to the 10-unit, the proposed 10-unit structure. So I'm just going to turn this off. Apologize for that. There is this is Highway 97, so people that would be accessing the unit would come down 148th and into the unit that way. This is what the proposal anticipated to look like. Ms. Duong had that imagery up on the screen. A fairly good looking building in the area. Again, the Act allows 10 units. The zoning bylaw allows 5. And the proposal is to allow 10 on this particular unit here. And if we were not allowed to do the 10 unit, we would do 2 5s. Of course, one would remain in the location as I indicated earlier, and the other would be down in here. So now we would have traffic coming down that portion of 148th to this area. And if we were to do 2 rather than consolidate to 1, there'd be approximately 35% more land that would be needed to accommodate the 2 projects rather than the 1. So having 1 project is clearly good for agriculture, as we're going to use significantly less agricultural land. A few points here, support and justification. The 10 unit would be consistent with the ALC regulations. Allowing 1 10 unit will consume 35% less land than 2 5-unit projects. Allowing 1 10 unit will result in no traffic occurring on the portion of 148th Avenue near the residential area at the east end of 148th Avenue. If the 10-unit agritourism is not approved, 2 5 units will be constructed. One will be on the lower portion of the La Stella Winery. And again, it'll result in increased traffic on that portion of 148th near the residential area. The owners are prepared and have prepared a covenant ready for registration that would be placed on the La Stella property that would preclude the construction of an agritourism accommodation on that project. And that's important because we wanted to ensure that the board and the public knows that we're not asking for anything more than what they're currently allowed, and that's 10 units. So if we put 10 units on the one property, the owners are prepared to put the covenant on the other property to preclude agritourism on that site. So there's no benefit being bestowed to the landowner in terms of the number of units proposed. The 10 unit will be nestled within a vineyard and separated and screened from the closest residence by approximately 0.23 kilometers of vineyard and a treed park area. And based on the location of the proposed 10 unit agritourism accommodation, access to the proposed project will be significantly buffered, and it will not have a negative impact on the use and enjoyment of any surrounding or adjacent properties. And I have submitted to the regional district 61 letters of support for the project, and those have been provided to the RDOS. And Mr. Chair, that concludes my report, and be happy to answer any questions.
Okay, thank you for that. I would ask, is there anyone else who wishes to speak to the proposed application? Don't believe I'm seeing any hands, so I'll ask a third and final time. Is there anyone else who wishes to speak to the proposed bylaw changes? I'm not missing anybody, am I, Danny, that you're seeing?
See, Rick has a hand up.
As far as the directors go, we can always ask questions later on when we deal with the application in the regular board meeting. This is more the formal public hearing. Not seeing any questions, so I will declare the public hearing closed at 9:14. Thank you, everybody, for attending. We will move straight into the committee meetings, the first one being Planning and Development, and I will go to Director Knodel to chair that one. Go ahead, please.
Thank you, Chair Pendergraft. Welcome to the Thursday, September 22nd, 2022 meeting of the Planning and Development Committee. I'm looking for a motion to accept the agenda. Motion by Director Bush, seconded by Director Trainer. All in favor? Any opposed? Motion carries. Are you opposed, Director Gittins?
No, sorry, I've just got a bear in the yard. I gotta just grab my dog, and I know the next thing is about me, so just give me 2 seconds.
All right, very good. I'm just going to invite the bear in, maybe. I don't think she's going to miss much here, so we're going to start by moving to CAO Knoll for a little description on item B, land use review, Meadow Valleys, and I do know that is Director Gettin's area, and I'm sure that she does want to be there for that. So when she returns, CAO Knoll, you can carry on directly. Thank you.
Okay, sorry.
CAO Knoll, please.
Thanks, Mr. Chair. So this is about the Meadow Valley Aquifer, and we've known that there's been a volatility in that aquifer. This is area F out in the Falder area. Also feeds Summerland as far as their water system goes. So we have a number of significant planning issues that we need to address out in that area, and water, of course, is a significant factor. So we did the Meadow Valley Aquifer study. The results were presented previously to the board, And we've now had a chance to consider those as to what impact they should have on planning. So Mr. Garish has a presentation, Mr. Chair, that he's going to share to discuss where we think we should be going with this.
Thank you, sir. Mr. Garish, please.
Great, thank you. Through the chair, I'll pass this one over to Ms. DeLong. She's got a PowerPoint that speaks to the options before the committee today.
Thank you, sir. Ms. DeLong, please.
Thank you, Chair. So I'm just going to really share my presentation here. Okay, and is this coming up okay for everyone? Perfect.
Thank you.
Yeah. So this presentation is on the Falder Zone Review, which was a project that we had originally initiated in August 2021. This was following concerns from residents with respect to water availability in the Falder area. And just to start off, I'll just go with a bit of a background here. Over the last year, staff and contracted consultants have worked to advance this project as per the direction of the P&D committee. And during the fall of 2021, the project and the associated amendment bylaws were sent to relevant agencies for comment. We had presented this at a public information meeting, and we had brought the project forward to the electoral area FAPC for consideration. And most recently at the December 2nd, 2021 meeting, the P&D committee had considered the proposed amendment bylaws and deferred any further consideration until we had completed the Meadow Valley Aquifer study. And as you may know, the study was completed in July 2022, and an associated report was finalized just last month. And the results of the study, as you may recall, were presented at the Environment and Infrastructure Committee meeting on August 4th, 2022. Now, the RDOS has previously undertaken a number of groundwater availability studies for the Falder area, as you may know. And the most recent aquifer study, which was completed by Associated Environmental, had built on these previous studies as a way to further develop the hydrogeological conceptual model for the Meadow Valley Aquifer. And their objectives were to better assess the current and future groundwater availability and capacity to support the various land uses that we see within the Falder and Meadow Valley area. Now, one of the conclusions of the study was that the Meadow Valley Aquifer is quite variable in nature, depending on where you sit within the aquifer area. And with this in mind, Associated Environmental had distinguished 4 distinct subregions based on geology, hydrogeology, aquifer geometry, and sources of recharge. And these 4 sub-areas or subregions include the North Meadow Valley, South Meadow Valley, North Falder, and Trout Creek Valley subregions. Now, so where does planning fit into this work? So local governments can use land use regulations and policies such as zoning provisions and OCP policies as tools to manage water usage. And while there were a number of different recommendations that did come from this study, the key recommendation that we're seeking to address as a planning department is the recommendation to limit or prevent additional development, land uses, or activities that draw water out of the Meadow Valley Aquifer within the Meadow Valley or North Falder areas. And given the P&D's previous direction to defer consideration of the amendment bylaws associated with the Falder Zone Review pending completion of this study, and the most recent completion of this study, staff are now seeking further direction from the P&D committee with respect to this project. And our administrative report outlines 3 different options: to maintain the status quo, amend the bylaws, or to abandon the project entirely. And I'll just discuss these in a bit more detail in the next few slides. Now, the committee retains the option to maintain the status quo, and that is to say that we could proceed with the amendment bylaws as they are currently drafted. The current version of the amendment bylaws have been provided as an attachment to the administrative report, as you may have seen. And specifically, this would mean that the proposed OCP policies would be inclusive of all of Falder and Meadow Valley, whereas the study had provided conclusions and recommendations that were specific to the distinct aquifer subregions that I mentioned previously. Further, the proposed zoning provisions would still only apply to the properties within the Falder water system, which we had previously proposed a small holding 7 zone for. So in summary, this wouldn't really address the recommendation of the Meadow Valley Aquifer study to limit or to prevent additional land uses and development, which would be drawing water from the aquifer within the Meadow Valley and North Falder subregions. The second option would be to amend the bylaws based on the recommendations of the Meadow Valley Aquifer Study. And more specifically, this would include updating the proposed OCP amendment bylaw to address those different aquifer subregions and the conclusions that were drawn from the study. Also, this would include expanding the proposed zoning provisions to include areas outside of the Falder community water system. And more specifically, that would therefore expand zoning provisions and restrictions to the Meadow Valley Aquifer area or the Meadow Valley area, and as well as the remainder of the properties within the North Falder subregion that's not captured within the community water system boundaries. Now, the previously proposed restrictions had included the minimum to increase minimum parcel size, prohibit accessory dwellings and secondary suites, and to prohibit agriculture as permitted uses. Updating the amendment bylaws would expand these restrictions and would also include a prohibition on swimming pools and review agriculture as a permitted use specifically in the North Falder subregion. And this is, as I mentioned in our report, there would just be a number of challenges to restricting agricultural use in the Meadow Valley area, just due to the presence of, first of all, ALR lands, as well as existing agricultural operations that would be entitled to continue as legal non-conforming uses in this area. And lastly, the board does have the option to abandon the project and not proceed with the amendment bylaws. However, this wouldn't be addressing the concerns that had originally led to the initiation of the Falder Zone Review or the Meadow Valley Aquifer Study. Now, should the board choose to move forward with options 1 or 2, we would need to carry out additional public and agency engagement just because of the length of time that's passed since we have originally brought these forward for public review and agency review, as well as the possibility of just having substantial changes to the text of the amendment bylaws themselves. And of these 3 options, the administrative recommendation is to amend the bylaws in order to incorporate the recommendations of the Meadow Valley Aquifer Study. And with that, that concludes my presentation, and I'd be happy to take any questions that relate to the amended bylaws themselves. However, we do have one of our consultants on the line from Associated Environmental, Marta Green, just to answer any technical questions that might come up regarding the study itself. Thank you.
Thank you, Ms. DeYoung. Are there any questions from Ms. DeYoung? Director Gettens, please.
Thanks, Chair. Thanks for the presentation. I have one main question, actually. Going forward with the administrative recommendation, and you touched on it a little bit, but can you just outline what the public engagement process is? A number of the citizens have reached out wanting to make sure that their voice is heard and having a conversation. And then the second part of that question is, actually, you know what, I'll just leave out that first part. So if you can just outline the public engagement process for me, that would be great. Thank you.
Ms. DeYoung, please.
We've discussed having an additional public information meeting, though we could certainly expand to further forms of engagement as well to collect additional feedback from the community that you see fit.
Director Gettens. Thank you. Director Coyne, Senior, I saw your hand waving there, sir.
Yeah, how would this proposed changes affect the right to farm legislation?
Ms. DeYoung, please.
In terms of right to farm, so as I mentioned with the Meadow Valley area in particular, because a lot of it is comprised of ALR lands, those lands would still be entitled to carry out farm uses despite, if our bylaws were to prohibit agriculture as a permitted use, you would still be able to carry out agricultural uses just on just the matter of fact that they're in the ALR. In terms of properties that are not in the ALR and would have agricultural use removed as a permitted use, they would not then, at least to my knowledge, be entitled to the right to farm protections.
Sure. Director Coyne, please.
Is that legal?
Yeah. Ms. DeYoung.
I might have to defer to Chris just for additional comment on that, but it's definitely something that would end up being referred to the Ministry of Agriculture for their comment.
Certainly, thank you. Mr. Garish, please.
Sure. So further to what Shannon was saying, least my understanding of the way the Right to Farm Act works is that it's not only parcels in the ALR, but it's also parcels zoned for agriculture, which is why the recommendations for the aquifer study area relating to potentially reviewing uses that are heavy draws on water presents particular challenges in relation to agriculture, because of course that is a use that draws heavily on water in the area. But I think at this point, in Shannon's PowerPoint, we're not specifically proposing removing agriculture as a permitted use. We just want to be able to look at what the options would be around that and what the implications are. But as Shannon said, or Mr. Wong said, there's a lot of challenges to that just with provincial legislation and the ALR. So we're not sure at this point what would come of that option.
Mr. Newell, I see you have something to add to that.
No, provincial legislation is superior to any municipal or regional district bylaw, so it would not affect the Right to Farm Act.
Thank you, sir. I assume Director Coyne, does that answer your question, sir? Thank you. Director Holmes, please.
Yeah, thank you. So when the aquifer study came to us in August, it didn't really seem that complete to me, and I'd asked if a referral had been made to the District of Summerland, and I think it hadn't. So, but if I remember correctly, we were told that that was going to be done, and so my question is, has that been done, and have we received any feedback? Thank you.
Thank you, sir. Ms. Young?
To my understanding, we have forwarded a report to the District of Summerland staff. I don't believe we've received any comments, although I may leave that to Mr. Garish to comment on as well.
Thank you. I see Mr. Newell has his hand up again too. Sir?
Yeah, the Meadow Valley Aquifer Study has been handled through our engineering department, and they have forwarded all of our documents to Summerland. And as recently as yesterday, we forwarded before the agendas went out, we forwarded it to Summerland. So they had an idea of what was coming in the administrative report. So I would say, yes, we've covered that, Mr. Chair.
Thank you very much, sir. Does that answer your question, Director Holmes?
I guess it would be nice for the board to know what the feedback from Summerland is.
Okay. Director Gettins, please.
Thank you. And just so everybody's aware, my dogs are in here and they might bark, so sorry about that. So my understanding is if we move the administrative recommendation, that we will get this information back to us from Summerland and that kind of thing. It's just directing administration to go and take more information, because we still haven't really had administrative recommendations based on the Meadow Valley Aquifer Study as well. So I'll move the administrative recommendation, please, and then we could just keep discussing it.
Thank you. Is there a seconder for that motion? Director Bush, second. Mr. Newell, I see you have your hand up. Is there an issue here?
I just wanted to clarify for Summerland that really the issues with the two Meadow Valley aquifers and North Falder they're fed by Dark Creek. The South Falder aquifer is fed by Trout Creek, and there really was not great concern with the quantity of water in that part of the aquifer. It's that our water license for the Falder water system is limited. And that's why we're recommending changes to the current development system. But my understanding is the water quantity is not a problem for Summerland. But we can, there is still an extensive process to go through here prior to any changes to the zoning bylaw. And perhaps we can get Mr. Stat to work with his counsel on what the Summerland issues are with the report.
Thank you, sir. Director Holmes, please.
Yeah, thank you. Yeah, I appreciate what the CAO said, and certainly any Summerland concerns would be with the recharge that originates from Trout Creek. You know, I think it needs to be recognized that Trout Creek flows are controlled by Summerland releasing water from Thirst Dam. And and any changes that are made, it's just the principle. It's not really so much the amount. It's just the principle that nothing there should be moving forward without agreement and working with Summerland on that. So it's, you know, I don't have a problem with the bylaw, and I understand it's, you know, Meadow Valley's Meadow Valley, but it's just the principle there. Thanks.
Thank you, sir. Mr. Newell, sir.
I'll just clarify again then, Mr. Chair, that we're not intending to apply for an expansion of our water license right now. That is quite a process through the provincial government. So as far as Summerland's concerned, with our withdrawal of water, that is status quo.
Thank you, sir. Director Gettins, please.
Thank you, Chair. And then, you know, what I'm really looking forward to hearing is from the consultant and how the recommendations of the report will impact the zoning or recommendations for the zoning bylaw for Meadow Valley and Falders. So I like to keep the conversation going, which is why I'm going with the administrative recommendation, please.
Thank you, Director Gettins. Any other questions at this point? Cannot see the boardroom clearly. Are there any questions from the boardroom?
Hands here.
I'm sorry, say again?
No hands here.
Thank you. So we have a motion on the board that has been seconded. I'll call the question. All in favor? Any opposed? Motion carries. Going forward. Item C, soil removal and deposition regulation bylaw area F again. CAO Newell, would you please, sir?
Thanks, Mr. Chair. So this is more with the West Bench and Greater West Bench area, and out of the previous official community plan review, of course, we know that the soils in West Bench are susceptible to movement. So there have been controls placed on certain activities within that area as far as development. But one of the recommendations out of the OCP was that we also consider soil removal and deposition bylaw to try and control more of the movement of soils within that area. And we haven't had one of these before, so it was an interesting process. We got to the point where we have now established the service for this type of permitting process. And this now is the regulatory bylaw that's coming forward as to how we administer it, Mr. Chair. So we're to the point where we've looked at a number of different aspects of this. Again, this will be one that'll be a trial and error because it's new for us, but we think we've got a pretty good handle on it. And I mean, we don't want to be prohibiting everybody that's working in their garden from moving soil around, but at the same time, where there are huge movements of soil, either the deposition of soil, which is the concern right now in West Bench, or removal, that would be a concern. So we think we got it, and we're now ready to move forward, Mr. Chair. So this was just sort of a last shot. We'll be bringing forward the regulatory bylaw. And if there is any concerns or questions from committee, I'm sure Mr. Garish would be prepared to address them. So we should turn it over to planning, Mr. Chair, and they can take you through it.
Thank you, sir. Mr. Garish, please.
Great, thank you, Chair. I'll just get my PowerPoint up and running here. Let's see. Okay. System seems to have, oh, there we go, frozen on me. Let's see if I can keep this moving. So further to what the CAO was just saying, so it is an existing policy statement within the OCP about a soil removal and deposition bylaw for the Greater West Bench area. This was also a recommendation within the recent geotechnical review, which was completed last year. There we go. Just some more background legislative context for the board's benefit. So Under the Local Government Act, the Regional District does have the statutory authority to regulate or prohibit the removal and deposition of soil and other materials on a parcel. I'll touch on this in some of the later slides, but there are potential areas of provincial interest in these bylaws. And in order to create a regulatory bylaw, as the CAO indicated, there must be a service establishment bylaw as well. So the service establishment bylaw was adopted in July. It is applying to a very small proportion of electoral area F, which is the Greater West Bench area. And the regulation bylaw similarly is applying to the same area. It's proposing to apply to both the removal and deposition of soil. And the terms that it's setting out is that unless exempt or permitted through the issuance of a permit by the regional district, no person may remove or deposit soil from land in the area to which the bylaw applies. Now, the way the bylaw is structured, there's basically three, I guess, ways to seek approval for moving soil on a parcel in the West Bench. The first is exemptions. And so the exemptions are setting out that public parks, trails, utility do not require a permit related to soil, so there are no limits. Similar for state of emergency declaration, or even soil is being removed within the parcels, or sorry, within the boundaries of a parcel. So no soil is leaving or coming onto the property. There's no limits in relation to that. It's exempt. Finally, we've put in an exemption for a mine permit, which is very important. And I'll touch on that again in a few slides. And so in that instance, the limits on soil removal or deposition would be set by the province. And then other than that, the general exemption is 25 cubic meters in any calendar year would not require any sort of approval from the regional district. Now, anything above 25 cubic meters up to a maximum of 100 cubic meters, the bylaw is proposing that a permit be required, and that soil in that amount has to be related to either the construction of a building structure, such as a house, a garage, the construction of an access driveway, or the construction of an in-ground swimming pool. And if the application, exceeds 100 cubic meters, there's potentially for a use not related to those three, that there's a possibility that it would be refused by staff. Now, for anybody who is seeking to exceed the 100 cubic meters, and this was one of the more difficult drafting aspects of the bylaw, the only way that this can be dealt with is through a formal amendment to the bylaw. Now, the benefit of this is it does invoke the board's discretionary approval. So whereas somebody who's applying for a permit and they meet the guidelines in the bylaw, they're generally going to be issued that permit. If you're seeking to go above the 100 cubic meters, because board discretion is now involved, it's not an automatic approval. The board has the ability to say no to those types of amendment applications. In situations when those proposals come in, staff are recommending that we publicly notify them to people within a 100-meter radius of the property under application, and we provide a period for comments to be submitted, and that the board can consider those at first reading of the amendment bylaw. And similar to some of our other land use planning application processes, that based on the feedback that's received on a particular proposal, that the board does have options for additional consultation to occur, such as requiring that a public information meeting be held. Now, I'll make the PowerPoint available to the directors after the meeting, because I'm going to probably fly through some of these slides here, but I know the key part of the bylaw is how it's structured around cubic meters. And so I want to give the board a sense of what kind of areas are we talking about when we have these 25 cubic meters, 100 cubic meter provisions. That said, I do want to say, take these pictures with a grain of salt. They're just from random Google searches. And to a degree, I'm trusting that the companies that put them up on the web, know what they're talking about. But obviously, I can't confirm that. So I'll start with the small ones, and I'll move my way up. So you can see here, generally the size of 15 cubic meters based on the bottom image. And of course, that's below the 25 cubic meters that we're proposing as an exemption cutoff. This is another one that shows it in the context of skips. I did struggle with this one, and it took me a few minutes to figure out what the issue was, but the difference between 20 and 25 isn't the size of the container, it's the size of the person standing in front of it, which is why when you jump from 25 to 30, it's such a big difference. But again, just that's that grain of salt, keeping in mind that these images may not be entirely accurate, but I think for illustrative purposes, they give an idea of some of the areas involved. And another image I found from an aggregate company in Washington State, again showing what they perceive to be the general size of crushed rock aggregate. So the important thing to consider here too, and I'll touch on this again when we get to enforcement, that dump trucks, at least my understanding from doing the research on this, is that they're restricted by weight, not necessarily by volume. So depending on what it is that they're hauling, if we have a 25 cubic meter exemption and the aggregate that's being brought to the property is really heavy, it might take 2 or 3 dump trucks to get it there, as opposed to, say, if it's bark mulch, that might be done in 1 truck. So the number of trucks going to a property may not be indicative of how much material is being brought to that property or being removed. So just something to keep in mind. And last example, again, just showing what can potentially be fitted in a dump truck. Obviously, the heavier material is at left and the lighter material is at right, which is why there's a difference in the cubic yardage shown. And just to recap, so the exemptions are 25 cubic meters, permits are up to 100 cubic meters, and then anything beyond 100 cubic meters would require a formal bylaw amendment from the board, which would then allow staff to issue a permit for that larger type project. Now I'm going to get, and apologize, that's it for my photos. These are some text-heavy slides that are coming up, but just some of the administrative aspects of the bylaw that I want to highlight for the board. So with the soil bylaw, much like the building bylaw, once this type of bylaw is adopted, it's a given that the issuance of the permits will be at the staff level. The key is that the board has to be satisfied with the criteria or the guidelines that we'll be using within the bylaw to issue the permits. So that gets back to the criteria about removal or deposition being for house construction or a driveway or a swimming pool and the amounts involved. The bylaw also sets out permit conditions that are to be considered by staff. And so when we look at proposals, we'll take into consideration impact on public utilities. Is there a likelihood of it increasing geotechnical instability in the area? Is it going to result in the unnecessary removal of trees or other vegetation, which again, kind of similar to the second dot point above, could lead or result in increased instability? And again, is the proposed project going to result in maybe an unacceptable level of dirt or debris on public roads? And if so, what measures can be put in place to try to address that? Permit administration, some further points. So the bylaw is setting out that staff will have the ability to cancel a permit, and that would be under the CAO's authority if he's of the opinion that activities being undertaken are contrary to either the conditions in the permit or the requirements of the bylaw. I know I've flagged for the board in the past some of the challenges we have around landscaping securities, but we are including a provision in this bylaw because we are anticipating there may be instances where there's major projects that come forward, and having that ability to ask for a sufficient security to ensure that certain works are undertaken or completed, we think is important. We're also proposing application fees be implemented for these to cover the cost of the regional district for processing applications. So a general permit, we're proposing at $150, and that the term of that permit be 1 year. Because there's an expiry date, we're anticipating renewal requests coming forward. So we're saying for those that the fee be set at $100. And because of the more onerous requirements in terms of a public notification for an amendment bylaw, we are proposing a higher fee for that at $500, and that an additional fee of $250 be applied if the board requests or requires that a public information meeting occur prior to first reading of a bylaw. In terms of enforcement, and I think this came up in relation to the noise bylaw proposal, so I just wanted to flag it here for soil as well, is that staff will be relying on the existing board enforcement procedures policy in relation to any soil bylaw that's implemented for the Greater West Bench. So we will be requiring of residents that they submit a formal complaint to us as a means to us initiating at least enforcement investigations on a property. With the soil bylaw itself, I just wanted to flag that we do think that the proximity of the Greater West Bench area to the main office is certainly advantageous when we're dealing with enforcement complaints, and it will certainly allow for staff to get there in a very timely and quick fashion to investigate. And again, just as I was indicating earlier, it is going to be a learning curve with this bylaw, much as it is going to be with noise. And just because multiple trucks are coming or leaving a property Again, doesn't necessarily mean that there's a contravention of the bylaw happening, but it will require investigative work to be done. We're anticipating challenges with just confirming the amount of soil that has been brought to properties, and I guess obtaining the proper paperwork that shows what was paid for and what was delivered. But we'll work through these as we get used to the bylaw. And just in closing off, my last couple slides. So I touched on this at the beginning. So a soil bylaw, the province calls it concurrent authorities. And basically what that means is that they do have a certain interest in a soil bylaw, and they want to make sure that it's not doing one of two things. First, it's not interfering with the mines permit. And second, from the Ministry of Environment's perspective, that it's not somehow related to, I suppose, allowing contaminated soils or other similar materials onto a property. So any bylaw that purports to do either one of those things automatically requires provincial approval prior to adoption. We're confident with the draft that's before you today that we haven't stepped into a sphere of concurrent authority. Obviously, the easiest one to address is Ministry of Environment's concerns. So the draft bylaw makes no reference to reviewing soil for contaminated materials or anything else along those lines. So we feel pretty confident with that. And with regard to the ministries, yes, there are prohibitions built into our bylaw when we're dealing with volumes above 100 cubic meters. But we feel that the exemptions that we have provided clearly indicate that it's not an outright prohibition bylaw. And of those exemptions, we feel the exemption for the mines permit is probably the most important one and shouldn't interfere with the ministry's concerns. That said, we are going to refer the bylaw to provincial agencies for their input. And if the Ministry of Mines does come back and feel that their interests are affected and that their approval is required, they have indicated to us that they have certain criteria, which we think we can satisfy if it comes down to having to get their approval. They have asked for technical information describing the problem. So obviously, as we're all aware, the West Bench is geotechnically unstable, so we feel we can address that. Reasons why the Mines Act or covenant wouldn't be sufficient. Supporting documentation such as a geotech report, which of course we already have because the geotech report for the West Bench was completed last December. And finally, any maps that we might have of the area of instability, which again, we can provide to the ministry through the geotech review for the West Bench. So we're fairly confident that ministerial approval is not required from Mines, and even if Mines comes back and says that it is, that we can satisfy their requirements to obtain that approval. So next steps would be, subject to any direction from the committee today, formally initiating agency referrals, notification of the public, and so this is going to be a two-pronged one for us this time. We're going to send out mailers and notices to residents and property owners. And we're also going to compile a list and reach out to various companies within the area that we think might be impacted by this change, such as local nurseries, landscaping or aggregate companies to seek their input. And looking tentatively, subject to availability of staffing and whatnot, a public information meeting. I know this is a very wide window, but ideally Q4, but there's a possibility it might be into the early next year, just to discuss the bylaw and again seek feedback. And at the end of that process, bring it all back for the board's consideration, again, hopefully in Q4 or Q1, and see if the board is prepared to consider first reading or possibly make changes to the bylaw. So thank you for listening to me. That's the end of my presentation. I'm happy to try to answer any questions that the board may have. And I'll just stop sharing.
Thank you very much, Mr. Garish. Are there any questions going forward for Mr. Garish? As such, I see no questions. I just have one clarification, sir. Ministry of Mines, for them to be involved, requires some form of resource removal, does it not?
Yes, Ministry of Environment would be deposit, Ministry of Mines would be removal.
Thank you, sir. Director Gettens, please.
Thanks, Chair. I just want to say thanks to the staff on this one. I think you did a really great job peeling back all the layers on this and trying to address this in a way that's reasonable and also addresses the concerns that we have. So I know you're not looking for a motion, but I'm happy to see this is moving forward. And I think just for timeline for bringing it back, it would be great if we could have this kind of more official by early next spring, because I know that's when a lot of the moving starts happening. So just for a timeline notification around that. But thanks again. It's definitely appreciated.
Thank you, Director Gittens. Director Kazakovich, I saw a tail up over on your screen. Is there a question from your cap? Thank you. Any other questions for Mr. Garish, please? Seeing none, Director Monteith, please.
To the chair, I had a question from a resident about how the fines were established for violation of this bylaw. It didn't. The opinion that I heard, and the concern was the value of the fine for not complying with this bylaw was not significant enough to deter anybody from, asking for forgiveness versus going through the process properly. So, how was the amount determined? Thank you,
Mr. Garish, sir.
I'd have to go back to my, sorry, I'm just quickly trying to recall here. I'd have to go back to my notes, but I think basically we reviewed the existing fines within the bylaw enforcement notice bylaw in relation to land use infractions. And granted, even though the soil bylaw is not technically a land use bylaw, the fee structure for the permit tickets was based on comparable land use infractions. So we just took direction from what we've done in the past, but if, certainly if the board would like to see higher fines, I think the maximum that we can go to is $500 per infraction. So that can certainly be reviewed.
Thank you, sir. Director Gittens, please.
Thank you. And I appreciate that question from Director Monteith. We did have a chat about this a little bit just with staff as well. And if there is a failure to comply, then there is that injunctive action that we take after that as well. I know there's some businesses that take the fines kind of as a cost of doing business, but we're hoping now that this is an actual bylaw that's being broken, that people will now follow it. Whereas before there was no bylaw being broken because we didn't have any rules to stop somebody bringing in dump trucks and dump trucks and dump trucks of dirt or fill. And now we're hoping that now that there is a rule, people will do the right thing. I don't know if that helps to clarify, but just for a bit of background. And then also trying to figure out a fine for somebody who just, made a mistake. So I think there's kind of a fine balance, but it's a difficult balance for sure.
Thank you, Director Gittens. Any other questions for Mr. Garish? I'm seeing none on my screen. I haven't got a full picture of the board. Director Pendergraft, are there any in the board?
I'm seeing no hands.
Thank you, sir. This was no motion is required for this one, so we're complete here. Moving forward, we're looking for a motion to adjourn the Planning and Development Committee meeting. Moved Director Gittens, seconded Director Coyne. All in favor? Any opposed? Seeing none, motion carries. We'll move out of the meeting. Thank you kindly, Chair Pendergraft.
Okay, thank you, Director Knodel. The main board meeting starts at 10 o'clock, so we have 6 minutes to fill your coffee or do a quick run wherever you need to go. So we'll catch you at 10 o'clock sharp. Well, I hope everybody's back at their seats. It's 10 o'clock, so we will call the regular board meeting to order. Looking at the agenda, this is a reminder that this is your opportunity to remove anything from the consent agenda. If anybody has anything that they want to remove from the consent agenda, let me know. I'm seeing no hands on that. I would also let the board know that item B5 is asked to be withdrawn by the applicant. They want to rework their application, so we will not be dealing with item B5 on the regular part of the agenda. It's withdrawn. So seeing no hands for anything to remove, looking for a motion to adopt the agenda as amended, moved, seconded. Thank you. All those in favor? Thank you very much. Any opposed? We have an agenda. Moving on to the consent agenda, corporate issues. Looking for a motion to adopt that. Moved, seconded. Thank you. All those in favor? Thank you. Any opposed? Motion carries. Consent agenda, development services. Looking for a motion for that one. Moved, seconded. Thank you. All in favor? Great. Any opposed? Motion carries. That brings us down to B1 under development services. Liquor and Cannabis Regulation Branch referral in Electoral Area D, CAO.
This is an application to the Liquor and Cannabis Regulation Branch, Mr. Chair, and they always refer to the local government for comments prior to approval. So, and they require a letter of support from the local government prior to approving an application. So this is a cannabis retail store in Okanagan Falls that's planning to move within the town center designation. We support the application, and then we provided the board with proposed comments that you could submit back to the Liquor and Cannabis Regulation Branch.
Okay, thank you. I'll go to Director Obrick.
Yes, thank you to the chair. And I just want to speak to it very briefly and support administrative recommendation. This one is very, very interesting. The store landlord gave notice. They found a location across the road. It's a couple hundred paces away. You can see it from the front door. I think the new location's a better location. The province gave very quick approval, but we learned that our bylaw doesn't have the ability to give a quick approval. So what we've done here is spent a lot of staff time and money going through a process and back to the APC to really permit something that's very reasonable, put cost to the community and taxes, of course, but put cost on the business owner, thousands of dollars per month and months of delay. So this board knows I've requested that this it's time for this bylaw to be reviewed and updated. I've asked for that. It's going to take a lot of years, I think, because we're behind on so much. But it's a detail we need to remember, because these are the things we when we learn, we can do better. And so I do support administrative recommendation. This is, and thank you to staff. They're stuck with the rules we give them. We need to fix the rules, because, you can't blame staff when they're following rules that need to be fixed. So thank you very much.
Okay, so you're moving it. Is there a seconder for this move? Thank you very much. It's seconded. It's on the floor. Any further discussion? I don't think I'm seeing any hands. This is a corporate vote, so I'll call the question. All those in favor? Thank you. Any opposed? Motion carries. Down to B2, a development variance application in Area A, CAO.
Thanks, Mr. Chair. This application for a single-family dwelling requires a variance of the rear yard from 7.5 meters to 1.5 meters, which is significant. But we've looked at the circumstances of the lot, Mr. Chair, and we are recommending that this application be approved.
Okay, thank you. Looking for someone to make that motion for me. Thank you, Director Bush. Seconded. It's on the floor. Any discussion on this one? I don't believe I'm seeing any hands. This is a rural vote. Call the question. All those in favor? Thank you. Any opposed? Motion carries. Down to B3, a temporary use permit in Area D, CAO.
This is on Bassa Lake, Mr. Chair, and we've seen this application before. It was initially before the board and was denied and was reconsidered. And there was a subsequent application to have fees reduced for the second application that was going to come forward, and that was somewhat approved, and that any external costs were to be paid by the applicant. And so the applicant has now submitted the second application, and it is back before the board for consideration, and we're recommending that it be approved, Mr. Chair.
Okay, thank you. I'll go to Director Olbrich again.
Yes, and thank you to the chair. I will speak to this very briefly, make a motion to deny, and then speak to a motion to defer. This file is just such a learning opportunity. We learned that the applicant didn't have fair access to the concerns raised in community, and that was the basis for the application to have it, as the CAO mentioned, reconsidered, and this board supported that request on fairness principles, which I respect. The community concern is amazing. We had an FOI request, lots of hours I put in reviewing documents. We've got 50-some plus pages in the materials today. Water is a real big issue on this one. If you read the materials, water is huge. And again, we get to learn. The initial process, the staff did not consult the water authority, the irrigation district. That was remedied on the do-over. There has been consult. The irrigation district board had a vacancy that had to be filled. Staff were advised of that. There were process they had to follow. There was people away. Now, they got the board position filled. They also engaged an engineer. The engineer provided a report that speaks to the issue of the water, which is relevant and material to the application. The chair of that irrigation district attempted to get that to us today. The chair of that irrigation district contacted me this week, expressed concern that staff advised it was not possible to get it to the board because the deadline was a week ago Thursday. I consulted the chair for advice. He referred me to the CAO. And because the information is relevant material, the board hasn't had it, I think the reasonable thing to do is to defer it so that one meeting, so that the applicant has fair and proper notice to respond. All of us have fair and proper opportunity to review the material. Quickly, it went before our Advisory Planning Commission, a couple of meetings. The first time it went to the APC, it was unanimous in support. On the do-over with more information, the motion to support was denied. It failed, the 3-3 split. This demonstrates community concern. When we look at the details, this is a learning file, lots of opportunity for balance, for careful consideration, for fairness. So I think in the moment, the motion I need to make is to deny the application and then to, after it's seconded, make a motion to defer to save this board the time today of getting into the details and to save the applicant, give the applicant fair opportunity to be prepared in 2 weeks' time for the a fair and proper consideration. So those are my submissions, and I do make the motion to deny.
Okay, so there's the motion to deny. Is there a seconder for that? It's seconded. So it is on the floor. I would go
like
back
to make the motion to defer. I think that gives the applicant time to prepare their remarks when they return, because they'll be allowed to speak to it, and I think that's the fair way to proceed.
Okay, that is a fact, and I'm seeing a hand, so that's seconded, I'm assuming. With the motions to defer, we generally don't debate them, so I will just go straight to calling that question. All those in favor of deferral? Okay, thank you. Any opposed? Director Kazakovich opposed? Seeing no other hands, the motion does carry.
Point of order, please.
Go ahead. Although
I'm confused. I thought the motion was to deny. We didn't have a vote, and now we're into a motion to defer.
Correct.
Could
Yeah,
someone
the
explain
motion-
that to me?
the motion is to deny the application, and he would like to defer the decision-making till the next meeting, which is
Thank you for the clarification.
sure. And that moves us on. Your hand is still up there, Director Kazakovich. Go ahead.
Yes, sorry, I just want clarification. With the motion to deny, we would not allow the applicant to speak before deferral? I just want clarification. So does that mean at the next meeting, we go straight to
The applicant would
to
speak then, yes, because the motion will come forward as a motion to deny, and he'll get to speak directly to it at that point.
Okay, thank you.
Okay,
Chair, if I could just
Before-
interrupt, sorry. Could you advise, I may have missed, was there a date or a milestone put on that as to when this would
the
come back?
next meeting,
Thank you.
October 6th, I think. Yes. B4, temporary use permit in Area E, CAO.
Thanks, Mr. Chair. So this is an application for a temporary use permit, and it's for a recreational vehicle for a year-round use on a residential parcel that's less than 1 hectare. It's as I understand it, an elder care type of a situation, as we've had many before. In this case, it is a recreational vehicle that won't be hooked into a community water system, and that is prohibited by the zoning bylaw. So we are recommending that this be denied, Mr. Chair.
Okay, I will go to Director Kazakovich for her direction on this.
Great, thank you, Chair Pendergraft. I'd like to make an alternate recommendation based on the well thought out discussion with our APC, and that's to approve the application with the following conditions. They are in your report, but there was 4 conditions. 1, that the RV cease to be a residence once the principal dwelling homeowner moves into a care home. 2, that the RV occupant is responsible for emptying the black and gray water bins of the RV regularly and does not use the on-site septic system. 3, that the RV occupant moves into the principal dwelling during the period between November 15th to February 15th annually. And 4, that the RV is not to be used as a vacation rental or short-term rental. And I can speak to that if it's seconded.
Okay, you're moving it. I've seen a seconder. Go ahead then, Director Kazakovich.
Yeah, thank you. And in hearing from the applicant previously, it sounds like her plans are obviously to move into the home just during some winter months, because it would be very cold to be living in the RV, because it would not be, as insulated, obviously, as a carriage house would be. So that is something that she wants to do. We have seen a letter in the package from IHA. And of course, their concern is the old septic system there. So that hasn't been inspected and deemed healthy. That's why the APC has indicated that we want the RV pumped out regularly. But there's also wording in there about the support for this, because it is providing support for aging in place for the elderly parent, and also providing space for each of these individuals to live independently. This is the first TUP for this, so we can see how this works out and if a renewal would be applicable or not in the future. Thank you.
Okay, thank you for that. So it's on the floor here. Any further discussion? I don't believe I'm seeing any hands. This is a rural vote. See you, Tim. Sorry. Director Roberts, go ahead.
Sorry, just a quick question. When they talk about regularly, is there a set timeline? Because again, just regularly is kind of subjective. I'm wondering if there was a suggested timeline. Thanks.
That's a good point. It maybe should be defined regularly, just so that could be something to hold them accountable to. Director Kozakovich?
Well, I think by that, it's really indicating that she's not going to be connecting to the septic system, and she's going to have to pump it out or she's going to have it backed up into her RV. So I'm not too concerned with the word regularly. She's going to have to do it as needed.
Okay. Director Knodel?
Thank you. Yeah, I kind of like this. I'm seeing pressure from seniors not wanting to go towards what we call institutional living, given the conditions of the pandemic over the last years. So I've got one coming forward in my area that's similar. But the question on the septic is, the house is has got a septic service for how many bedrooms and how many people in the house, and if it's not being fully utilized for the purpose of that house, perhaps it could be hooked in. It's just something to consider. If the house has 4 bedrooms, 3 bathrooms, and only 2 people living in it, then the septic service that's existing is being greatly underused. So, it's possible to take consideration there. Thank you.
Okay, thank you. Director Kozakovich?
Yeah, thank you for that, Director Knodel. The IHA letter indicates they don't have records on file because this is quite an old house, so they're not certain of the health of the septic system. So I'm thinking if it was inspected and is in good condition, then in the future, the applicant might be able to look at having it tied into the system. But because we don't have that information, and IHA was concerned about that, we've gone this route with a recommendation. Thank you.
Okay. Thank you. Seeing no more hands, I will call the question. All those in favor? Thank you. Any opposed? Motion carries. Over to B7, Noise Control Bylaw, CAO.
Were you going to do B6?
Did I miss one? I did. Sorry. I skipped B5, but I shouldn't have. So B6, Zoning Amendment for Electoral Area I, CAO.
Yeah, this is a property owner at Apex that wants to build a single-family dwelling in a multifamily zone. And the zoning doesn't permit a single-family dwelling. We're recommending that the zoning amendment to permit that be approved, Mr. Chair. So we're recommending first and second reading on that, and then it go to public hearing on October 6th.
Okay, thank you. I'll go to Director Monteith.
To the chair, I'd like to make the administrative recommendation, and then I have a comment.
Okay, so you're moving it. Is there a seconder? Thank you. Go ahead, Director Monteith.
To the chair, so I just want to share that I definitely support where the applicant is going. He's definitely done his due diligence. So I appreciate that he bought property, just kind of assuming that he could go to that single family dwelling, even though it was zoned for the duplex. But I do want to encourage the regional district to make sure that we are continuing a dialogue and an open relationship with our First Nation neighbors, because I have heard some concerns just about process with them. So not specific to this application in general, but I think that there is some concerns about change and just making sure we're building that relationship, because it just needs a little strengthening.
Okay. Any further discussion on this? I'm not seeing any hands or arms waving. This is a rural vote, so call the question. All those in favor? Thank you. Any opposed? Motion carries. Now we're over to B7, Noise Control Bylaw, CAO.
Yeah, so this is a consolidation of a number of electoral area noise control bylaws, Mr. Chair, and of course H has been removed. But this now sets out more objective criteria with decibel readings and setting up different zones as to what types of noise can be undertaken in an area. We did have it up previously to the board and it was deferred so we could get a better reading on the speedway and for the quarry up in area F. And we have readings on those now. We think that shouldn't be a problem. So we are now recommending that this be read first, second, third time, Mr. Chair. And then we'll also have to do the bylaw, notice enforcement bylaw for 3 readings. So we're recommending that proceed.
Okay. Direction from the board on this. Director Knodel, I see a hand. Are you moving it?
No, well, at first I'd like to know, apparently we did some readings. I just kind of like to know what they came out at, just for curiosity's sake. Thank you.
Okay. Mr. Newell, do you know that, or is Mr. Garish available, or whom would I ask for
Either
that?
Mr. Garish or Mr. Petrie would know that, Mr. Chair.
Okay. Mr. Garish, I see your name on there. Go ahead.
Sure, thank you. So I'll have to start by saying I think it was Mr. Petrie who did the measurements, but what he conveyed to me was that in relation to the aggregate operation in the West Bench, he was able to get there while they were operating some of their equipment. And I believe that the decibel measure that was taken was around 55 dBA. We also had a meeting subsequent to the, or sorry, following the last board meeting with the operators of the Penticton Speedway. And as the board will see in the information before you today, we had originally proposed a 95 dBA level for the Speedway. As it happens, the Speedway folks have their own measuring instruments. And after we contacted them, they took some measurements themselves, and what they came back with was 98 dBA. So we weren't far off. It was a difference of 3 dBAs, but those are the 2 measurements. And then I did have those slides that I presented previously where we had taken measurements of just various construction activities. And for the most part, those seem to be in the range of 55 up to about 85 or 86 dBA, depending on what the actual machinery was. So I hope that's of some assistance.
Okay, thank you for that. Direction from the board on this. Someone ready to move it? Moved. I see a seconder. Thank you. Discussion? Director Gettens, your hand's up.
Yeah, thank you, Chair. So I'm going to vote in favor of this, and with recognizing that we haven't done this before with the decibel readers, but I think the positive step here is we are removing some of the subjectivity of our noise bylaw and making it a little bit more measurable and objective. So I'm willing to vote in favor of this and test it out and see if we can make it work for us. So I appreciate the work by staff.
Okay, thank you. Director Olbrich and then Director Monteith.
Yes, thank you to the chair. I had a question. I don't know if I missed the chance. I really appreciated Director Kazakovich's concerns about the Speedway, and staff looked into that, and I find it fascinating, 98, 95. My question is, I'm not clear that I understand, does this bylaw as it's being presented, is it reasonable on that 98? What is the limit on the Speedway? Are they in violation on the first day, or what's the limit for them, and how does that work? Thanks.
I think I should probably go to Mr. Garish for that response.
Sure, thank you to the chair. So further to some of the investigations we've done on this bylaw, so there is no grandfathering provisions under the Act. So as soon as the bylaw is adopted by the board, the standards in the bylaw apply. And then the expectation is that the uses affected by those decibel levels would be in compliance as well. And if they're not, then subject to written complaints being received, we would investigate and potentially be in a situation if there is an infraction of ticketing. And so with regard to the Speedway, we had looked at we did, again, just searches for where other similar types of motorsport facilities operated. We looked to see if those local governments had noise bylaws. We found a number of instances where they did, and they had decibel levels set out, but it was a significant range, I think from a low of 65 up to a high of 95. So being potentially a little bit overly cautious, we went with the higher level for the Penticton Speedway, which was the 95 decibel the board previously considered. Yeah, we were heartened to hear that we weren't far off when the Penticton Speedway folks said that their measurements were 98. But I appreciate that given the location of the Speedway, it is in a rural residential area, but it also has been there for a significant amount of time. So I think there's an understanding, at least I hope, amongst residents that this use exists and operates and does generate noise. Is 98 versus 95 reasonable in comparison to what some of the other local governments had, particularly if it was 65 decibels? It's hard to say. Again, I don't want to sound like a broken record, but until we actually start working with the bylaw and seeing, what the levels from the Speedway are, and is it in that 98 decibel range, it's hard to say if it's reasonable or not.
Okay. Follow up, Director Olbrich?
Yes, thank you to the chair, and thank you for the answer. I can't support the bylaw as it sits. They're at 98. They're in violation on day one. They've been there forever. I know history in this community. There's lots of history of complaint about noise that I've heard. And so I don't want to see us setting up neighbors where on day one complaints can go in and we're going to have enforcement opportunities. And so I would prefer, a slight amendment to 100 just to put them on side on day one. I appreciate the live and learn. We're doing that with the cannabis and the short-term rentals, and we can see how hard it is to fix those bylaws when we learn that they're not working. I don't want to start on day one with a long-standing community member who creates jobs, economic benefit to the greater region, being put into being told they're already gonna be violating this new law and there's no grandfathering. I do have trouble with that, and I don't know if anybody has a better suggestion on how to approach this. Thank you.
Okay. Mr. Garish?
Thank you. Through the chair, if I can just clarify. So the 98 decibels for the Speedway is the number that the Speedway put forward as a level that they could operate within. So our hope in putting this before the board today is that we aren't creating a situation where they're going to be in contravention of the bylaw on day one. And just to keep in mind too, we did present that chart to the board previously. When we get to 100 decibels, I think that was using the graph from WorkSafe BC, the point at which noise is deemed to be harmful to one's hearing. So to put a use up to 100 decibels is, it's certainly an option for the board, but it does get into a range that may not be advisable.
Okay, thank you. I'll go to Director Monteith and then Director Knodel and Kazakovich.
To the chair, so I have had a little brief chat with some of the residents in my community that had some concerns about this bylaw. And some of the questions they had were, what model would the RDOS be using? Because, the last meeting we talked about not recommending residents use the app on a phone to track these decibel readings, but if we're not giving them a model or some sort of benchmark on the standard of decibel reader for them to be able to have a fair reading before making a report. They felt that was setting them in a position of once again going against neighbor when things would be normally fine. So they felt that having that information was vital. The other part that they brought up, which is very valid, that we should be communicating the process of a complaint in this new bylaw change, as well as making it, the question was, is it one complaint or two complaints before there's action? And what would be the repercussion of a repeat offender? So there was lots of great conversation and questions, and I feel like we need to have those answers.
Okay. Is there a response to that from Mr. Garish?
Through the chair, again, it's going to be part of the learning process for us, but further to the concerns we expressed at the last meeting, by all means, residents can use their phones to take measurements of noise. But I suspect we are not going to be relying on those measurements for the issuance of permits or determining contraventions of the bylaw. It would certainly be helpful for us to know that there's an issue, and that's why they're contacting us. to make a complaint because they've got a measurement that they think exceeds the bylaw, and then we can send our staff out with our equipment to take the measurement in accordance with the way the bylaw is setting out that the reading should be done, and we can proceed on that basis. And I mean, there is no change proposed for how complaints are processed by the regional district with this bylaw. It's simply adhering to the board's existing enforcement policy. But I mean, certainly we can try to do an education campaign with residents around how one submits a complaint to the regional district, and you know, how we will respond to those.
That's a good suggestion. Director Knodel?
Thank you, through the chair. Currently, now we phone bylaw comes out, puts their ear to the wall, so to speak, and depending on the opinion of the bylaw officer, it's whether it's too loud or not. So the addition of a meter doesn't really change the process in any way. It just adds a quantitative value for the bylaw officer to rely on. And again, two different bylaw officers may have different opinions. So this just gives a steady value. The other issue is on the racetrack. Depending on where they take that measurement, they can back up 5 feet and drop a decibel quite easily. So if they were standing next to the racetrack when they were doing it, as opposed to standing at their property line or the property line of the complainant, you may see considerably different decibel readings. I did a little reading on that, and it's quite a substantial drop in decibels as you move away. Granted, the speedways are a little bit noisier than normal, but there are a number of activities out there, including monster truck rallies, where they actually advise people that the noise is above the safe level. So this is an activity that has been there in the past, and we're going to have to institute some form of a permitting system also, because we will have public affairs. Everything from concerts to even a fair could easily go over the noise. So we're going to have to figure out a gateway for that to be acceptable. Otherwise, we basically shut our whole area down. And that's not the intention of this bylaw. The intention is strictly to allow a consistency inside these systems as we use them now, as opposed to just using the ear of different bylaw officers. Thank you.
Okay. Director Kozakovich?
Yes, thank you, Chair. So two things. I would certainly hope that the bylaw enforcement officer is not taking a decibel reading right beside the track or at a fair, because the complainant is not attending that event. So they're hearing it from further away. So I'm not sure if we've sorted out, is that at the property line of the speedway or where an event is, or is it from the homeowner's house who is feeling the noise is traveling too far to where they are? That to me seems more appropriate. And then I just wanted clarification on what Director Oberich had mentioned. So if they've tested at 98, they're not going to be in violation right out of the gate, because in this bylaw, we've amended it to increase it to 98 from 95, correct? Yes, okay.
That is correct.
Good. Thank you.
And Mr. Garish, could you clarify her first question?
I apologize to the chair. I was focused on the second part of the question, and now the first one escaped my mind. So can somebody remind me what the first part was, please?
Director Kozakovich?
Sure. Mr. Garish, I was just mentioning that I don't think it'd be appropriate to do, if there's a complaint come in, to do testing right beside the track or at a fair event, because the person's not there. They're complaining from their home. So I'm just wondering where testing would take place.
Yeah, so through the chair. So again, this is it's certainly going to be a learning process for us, but the bylaw currently sets out basically two ways in which we will measure the sound. And I won't get into all the details, but option one is that we take the measurement from the location of the person who lodged the complaint with us. And I think, as we discussed at the previous meeting, the second option, and we're not quite sure, I mean, again, until we get it into the field and start using this, when the second option will come into play. But the second option is that we stand, I believe it says 2 meters or 6 feet or something along those lines from the parcel line from which the sound is emanating, and take a measurement from there. So until we actually start responding to complaints and getting out on site and determining what the best way to measure those sounds are, it's difficult for me to say which one is going to be the more common of the two. I suspect it'll be the one, if I had to guess, from the complainant's location. Start from there. But if that's not possible, then I suspect the other option would then be used.
Okay. Seeing no more hands. Oh, Director Olbrich, go ahead.
Thank you to the chair, and thank you, Director Kazakovich and Director Knodel. I find your comments very, very helpful. I appear to have been misunderstanding Mr. Garish. I thought the answer to my question was that it was 95 for the Speedway, but just to double check, it's 98. So 98 I'm okay with. I totally misunderstood, so my apology. Thank you.
No worries. Mr. Director Knodel.
Thank you. Through the chair, just it seems to me that reading through this, there's also a degree of subjectivity where necessary. Is that correct?
My recollection was yes, but Mr. Garish?
Yes, so through the chair, there is a provision in the bylaw, and again, without knowing or having experience with the bylaw, but there's a provision in there that's been built in specifically to address situations where, and just guessing, but we respond to a complaint and the bylaw officer gets out there and the battery's dead, the equipment's broken. We don't have a mechanical means of measuring decibels, but he's on site, he's responding to a complaint, so he can rely on what he hears as the basis for determining if it's in contravention with the bylaw. So, hopefully that's not a common requirement for the bylaw officer, that the equipment is able to make the measurement as required by the bylaw, but it's kind of a fail-safe within the bylaw for those other types of situations.
Thank you, sir.
Okay. I don't believe I'm seeing any more hands, so I will call the question. This is a participant vote, so it's just those that are named in that bylaw, those areas that are named in the bylaw. And just for information, that's C, D, E, F, and I. So all those in favor? Thank you. Any opposed? The motion carries. That brings us down to proposed amendment bylaw for notice of bylaws. CAO B8.
This is regarding the changes that we made previously regarding mobile vendors in the zoning bylaws, Mr. Chair. And in doing so, we have yet to change the numbering in the bylaw enforcement notice bylaw. So this is more or less a housekeeping issue for us, is that we have new numbering that we have to address. So we're recommending that this get first, second, and third reading and be adopted, Mr. Chair.
Okay, thank you. I see a hand from Director Trainer.
Was there a second vote that we had to do for B7, or did I miss something?
We kept that all together in one motion.
We did?
Yeah.
Okay, even though it says weighted
So,
corporate?
Yeah, it's a different vote.
We do have to
Oh, it is.
separate it. Good catch.
Yes.
Okay.
Good catch, thank you. We'll go back then to B7 for the second part of that, because it does need to be a corporate vote for the second portion. Looking for a motion for it. Moved, seconded, thank you. Any discussion on it? Seeing none. Corporate vote, all those in favor? Great, any opposed? Motion carries. Thank you, Director Trainer. Now down to B8. We've had the intro on it. Direction from the board on this one. Someone willing to make that motion? Moved, seconded, thank you. Discussion? Not seeing any hands. Again, corporate vote. Call the question. All those in favor? Thank you. Any opposed? Motion carries. B9. This was the item on the public hearing this morning. CAO.
Yeah, this is 10 agritourism cabins in electoral area A, Mr. Chair, and we're recommending that this get third reading. And then also this is one of these two-part motions that you'll have to do, Mr. Chair.
Have noted that. So looking for a motion on the first portion of that. Moved, seconded, thank you. Any discussion on it? Don't believe I'm seeing any hands. This first portion is a rural vote. So this is for third reading. All those in favor? Thank you. Any opposed? Motion carries. The second portion of that. Looking for a motion. Moved, seconded, thank you. Discussion on this? Seeing none. Again, corporate. All those in favor? Thank you. Opposed? Motion carries. Over to B10, Public Notice Bylaw, CAO.
Yeah, this is with regard to the province loosening up regulations for the advertisement of public hearings, Mr. Chair. So this is now back ready for adoption. And then we also have to amend our development procedures bylaw, and that's ready for adoption. And again, the two-part vote.
Okay, thank you. On the first portion, it says it's a corporate vote, so moved, seconded, thank you. Discussion on this? Director Gettens.
Thanks, Chair. I just wanted to acknowledge that we do have some citizens that do really rely on that newspaper. And I'm just wondering, you know, with Voyant Alert and incorporating, you know, that system into a better way of communicating with our citizens, can we put together like a communication plan that promotes Voyant Alert? And you know, I don't even know if it's worth doing like a mail out to all of our citizens or something like that, because I do know we have a few citizens that just aren't online, and I just don't want to lose their input either. So if I could just get that addressed, that would be great. Thanks, Chair.
Okay, thank you. Is there any thought on an education plan, or Ms. Malden?
With respect to Voyant Alert, we're just working out a few small bugs left over from the EOC. Of course, that was our first time using it through an EOC. And so once those are worked out, we do plan to start to heavily promote Voyant Alert and do various different types of outreach in different communities to ensure that as many people as possible are on it. And then, you know, implement it quite a bit more in our general communications plans for any issue that we undertake or any program or process that we put out to the public. So we'll be using it quite heavily in 2023, and we'll be encouraging more people to sign up for it.
Okay, thank you for that. Any further discussion or questions? Seeing no hands, this is corporate. All those in favor? Thank you. Any opposed? Motion carries. Down to the second portion of that. Mover, thank you. Seconded, thank you. Rural vote, any discussion? Call the question. All those in favor? Thank you. Opposed? Motion carries. Brings us down to C, Finance, Purchasing and Sales Policy Amendments, CAO.
We had the purchasing and sales policy corporate services about a month ago, Mr. Chair, and Mr. Sfino went through an extensive review of the policy and pointed out the changes. So this now is the clean version that has come back from that and is ready for adoption as amended.
Okay, thank you. Direction from the board on this? Someone ready to make that motion to adopt? Moved, thank you. Seconded, perfect. Any discussion on it? Director Monteith?
To the chair, has the fire departments been communicated with this policy change? The last time this came forward, I had a concern about the fire departments having a change and wanted to know if there was any communication with them yet.
CAO? Any
I'd have
idea?
to refer the consultation process to Mr. Sfino.
Okay.
Hopefully,
Mr. Sfino?
Yes.
Yes, go ahead.
When I did the consultation with the managers, I also included the fire department with meetings and the proposed changes. And tonight, we're just going to do the final one to show them there were some minor changes from when I originally talked to them to now. So this is just a catch up. I don't see any issues with the fire department. Some of them did phone me once I proposed it to the board. I explained their concerns, and I don't believe there's any issues.
Okay. Director Monteith?
To the chair, I don't know if I'm comfortable passing a policy that we don't have everybody's buy-in, especially with all the managers. So I would like to make a motion to defer.
Okay, so you're moving deferral. Is there a seconder for that? Seconded. No discussion on deferral. This is a corporate vote. All those in favor of deferral?
Sorry, Mr. Chair, can you tell
Yes.
us what it were referred to?
It would be the next meeting or opportunity to confer with all managers. Next meeting would be the proposed date, I should say. So again, I'll call the question. All those in favor of deferral? Thank you. Any opposed? Director Johansson and Roberts and Bauer, Bush and Sentes, Coyne. Did I miss anybody? And Miss Malden, what is the count on that? I kind of lost track on my counting.
I got 5. Director
Okay, so the
Johansson,
motion,
Director Roberts, Director Bauer, Director Bush, and Director Coyne. Am I missing anyone?
I'm not seeing, Director Sentes, so it would be
Sentes.
6 then. So
Yeah.
the motion still carries.
Yes.
Okay, so that will be dealt with at the next meeting. Legislative services in item D1, OK Falls Irrigation District Conversion Services Establishment Bylaws, CAO.
We're getting closer to the transfer of the 4 services that are currently operated by the Okanagan Falls Irrigation District, Mr. Chair. And we need to set up our establishment bylaws for the appropriate services. So we have 3 bylaws here. The first is for the water service, and the second is for the street lighting service, and the third is for the cemetery service, all out of the Okanagan Falls Irrigation District. Centennial Park, which is also an operation that will come over, will be fit within the Okanagan Falls Parks and Recreation Service. So nothing additional needed there. So we are recommending that these 3 establishment bylaws get 3 readings and be forwarded to the Inspector of Municipalities, Mr. Chair.
Okay, thank you. Direction on this? Director Olbrich?
Yes, thank you to the chair, and a big thank you to staff. This is a real important piece of work in OK Falls. This began less than a year ago when the formal request came in from the irrigation district after a meeting held with help from staff on October 13, 2021. To see this much done this quickly and the support of staff is so very appreciated. I would like to move the administrative recommendation.
Okay, moved. Seconded, thank you. Any further discussion on this? Not seeing any hands. Again, this is a corporate vote, so all those in favor? Thank you. Any opposed? Motion carries. That brings us down to Section E, CAO report. Anything from the CAO?
Nothing new from me, Mr. Chair.
Okay, thank you. Brings us down to other business, the chair's report. Let's deal with the first item on there, which on the agenda is F11, which is the South Okanagan Smilkameen Fire Chiefs Liaison Committee. And that was a recommendation to dissolve effective immediately. And I will just state, this came from myself. I think we're to the stage now where the liaison committee needs to step out of that spot of kind of being in the middle between the CAO and the fire chiefs and let the fire chiefs deal with the CAO directly. As directors, we're always available to the fire chiefs or any citizen at their request or need. So is there anybody prepared to make that motion? Moved and seconded. Thank you. Any discussion on it? Director Olbrich?
Yes, thank you to the chair. And having served on the committee, all the members of this board who were from the previous term, I remember when I was first elected, told me what a mess, that past experience was, the Mitchell report and all that history. And the committee, I think, served a valuable function. We assisted in facilitation through difficult process. I remember June 6th, when legal counsel brought it back to us and said we got it done, which was good. There's been a lot of progress. I'm not opposed to the dissolution of the committee. My question is, we need to do better. I have not seen our fire chiefs report out to this board, I don't think a single time in 4 years. We hear from the police, we hear from Modi, we hear from every other department. And I really think if we had them reporting out, they have an association, they have excellent, oh my gosh, if you get to know these fire chiefs, every one of them has experience. I mean, Chief Dennis Smith at Naramata, my gosh, that guy has experience. We look at Chief Dennis
Godry.
Thank you. Out of Kaleden, oh my gosh, the experience is unbelievable. This board, I think, would benefit from quarterly reports from that fire chiefs group. They have concerns. Those concerns need to come to this board. We should hear from them, just like we hear from all the other departments. So those are my submissions, but thank you so much for listening.
Okay, I seen a hand from Director Knodel. Go ahead.
Thank you, and I really have to thank Director Olbrich for that suggestion. That's absolutely outstanding. It's something that should be happening. There is one question still outstanding that we're going to have to deal with, is the placement of the fire chiefs and fire departments on the RDOS organizational chart. And I believe that's on your roster of things yet to deal with. There was some concerns from them earlier on that, that they were left off that organizational chart. So it basically makes them a non-entity inside the RDOS until they see their names on that. So if you would, please, thank you.
Okay. Seen another, Director Kozakovich, go ahead.
Yes, thank you, Chair. I agree, we should be seeing quarterly reports from the chiefs. This board has seen maybe a couple times a quarterly report from the Naramata Fire Chief in the consent agenda minutes. And he does try to get quarterly reports to the CAO. They are managers of their department, so I believe they should be submitting quarterly updates as all the other managers do with the RDOS, and that the board should be seeing those at least in the minutes, and possibly inviting the chiefs to attend the board once a year to give a more formal and in-depth update. Thank you.
Okay, all good suggestions. Director Roberts.
And I'd also like to suggest, since these people are considered managers, as per our policy, I think they should all be required to be involved in individual 360s. Gives them a good footing in knowing where they stand with their crews and their staff, and at the same time gives them a sense of security moving forward, knowing that they're meeting their obligations. Thank you.
Okay, thank you for that. I don't believe I'm seeing any other hands. So the motion on the floor is to dissolve that committee effective immediately. I'll call the question. Corporate vote, all in favor. Thank you. Any opposed? Motion carries. And then on to the chair's report. As everybody's aware, UBCM was last week, and I think the vast majority of those of the board members attended, so I won't go into great detail on what happened, but I will mention a couple of things. We did have 6 ministers' meetings that I attended along with the directors that were involved in that. The majority of those went well, but as usual, we never really know until we actually get that written response back from the ministers, really kind of giving us an indication as to whether we made any ground or not. So it's still wait and see in that regards. Also, I would, and I'm pleased to say that we did win an award at the UBCM award ceremony. I'll just grab it here. I'll try to hold it up so it can be seen on the screen. It was under the category of excellence in government, and it was our policy in regards to acquisition of utilities. And I think it came about from probably the one that we dealt with today in OK Falls. And if I'm not mistaken, I believe it was, I will get to her in a sec. I seen a hand there. I believe it was Andrew Reeder who suggested that this go to the awards or be submitted, and we were successful. So I thank Andrew for putting it forward and thank the few members that were actually at the awards to get it with us. So congratulations, everybody that was involved in that, and I believe it was mostly staff. So we take the credit and they do the work. Thanks, staff. This will go to where it's, I think there's a case that it goes in, so it's available for anybody to view there. I believe that's it for the chair's report. Board representations. The first one is Municipal Finance Authority. I did attend that meeting at the UBCM. It was short. I was actually surprised how short, but things are going well with Municipal Finance Authority. I don't believe there's much I can say verbally that would be of much interest, but there is a report that we'll put a link to that anybody who wants further information can look that up. Municipal Insurance Association was another one that I attended, and I assume there was probably other mayors and stuff at that as well from the municipalities. I would just point out that I found it quite interesting during the Municipal Insurance Association. There was a quick discussion from Minister of Municipal Affairs, and he really didn't understand what the Municipal Insurance Association was until it was explained to him. He said he actually refused the invite to, because he didn't want to speak to a bunch of insurance people. But once learning about it, he was quite impressed. So I guess we're all learning, including the municipal Minister of Municipalities. Down to OBWB. Anything to report there? Director McCordoff.
Yes, thank you very much. We held the annual meeting of OBWB on Friday, September the 9th. It was in Kelowna, the first one that has been in person for the last 3 years. And it was very well attended by quite a few people, including some of our board members. We did have a keynote address by James Litley, who is the Okanagan Basin Water Board Deputy Administrator, on the past, present, and future of milfoil and mussel in brackets. And he had some wonderful slides to show what had gone on, what they're doing now, and how we continue for 50 years to deal with milfoil issues, including, of course, Vassal Lake, which is the newest one this summer. So I think it might be available for anybody who was interested in looking at it on the OBWB website. But that's all I have to report for now. Thank you.
Okay, thank you. And I believe I omitted to go back to Director Gettins for a question or something. No? Okay. But you're up next for Okanagan Film Commission. So please go ahead.
Great, thanks, Chair. This weekend is the Okanagan Film Fundamentals course. That's that 3-day course for people trying to get into the industry. I just got the agenda here and it looks amazing. I understand there's about 160 people registered. People are coming from Saskatchewan and even Prince George down to joining us here. This is huge for the industry because it means we're going to train locals to support this industry. They're great paying jobs. There's a lot of work to be had at the moment. So the coursework is around, they're having a writer's session, so a Q&A session with writers, also with production, so that's designers and cinematographers, and also along with directors. They break up into 4 different groups. So there's the camera, grip, and lighting group, the art department, production, hair, and makeup, and costumes. That's on day 2. And then I believe they actually each make a short production as well. So this is hugely beneficial to those that are wanting to get in the industry. And it's pretty exciting that it's sold out a couple of times because they kept upping the tickets until they could. So congratulations to the Film Commission. It kicks off tonight in Kelowna.
Okay, thank you for that. Okanagan Regional Library, Director Monteith, anything there?
I believe we have our next, sorry, to the chair. I believe we have our next meeting next week or the week after in Kelowna, which will be our final meeting before the election. So it's kind of nice to see the gathering, of course. We haven't had a lot of in-person, so it'll be a good opportunity.
Okay. Have you guys gotten a CEO yet?
We are getting very close.
Okay, so it's still in progress. Good. Okanagan Sterile Insect Release, Director Bush.
Yes, nothing to report.
Okay. Simia, Director Knodel, anything there?
Typically exciting, no, nothing to report.
All right. Startling Control, back to Director Bush.
Again, nothing there.
Nothing from the Fire Chiefs Liaison Committee, and in future, just a note to staff, that one can be crossed off. Intergovernmental Indigenous Joint Council, nothing to report there. Okanagan Smilkameen Regional Hospital District.
Thanks, Chair. Nothing specific to the hospital district, but everyone that attended UBCM, I'm sure, attended a number of conversations and panels with Minister Adrian Dix, and healthcare was a huge topic. And if there was one thing that was resonating, it was everyone voicing their concerns with interior health and the lack of engagement of interior health and collaboration. So moving forward, I think that message is going to be relayed up to Susan Brown at Interior Health, and I think it's going to help hospital districts around the province to deal, at least in our area, to deal better and get more timely answers and more of a working relationship. So I look forward to that.
Okay, thank you for that, Director Johansson. That completes the board representations. Directors' motions. Any motions from directors? I thought there was one possibly from Director Kazakovich. Is that the case? Go ahead, please, Director Kazakovich.
Yes. However, I was waiting. I understand that either yourself or Director Knodel was maybe making the motion from the recommendation from Dale Cronenbush for the grant opportunities for the volunteer fire departments. Is that correct?
Nothing had came to me, but maybe Director Knodel has.
Because if not, then I'll be making a motion right now for Naramadas to be supported, but maybe Director Knodel knows.
Sure. Director Knodel? Oh, you're muted.
Yeah, I haven't had an update on that from Tony yet, but I definitely support that we move forward with those grant approvals.
Okay, so maybe, I'm not sure when the deadline is on this, but is it able to be dealt with at the next meeting?
Yeah, if I could go ahead, Chair.
Sure. Go ahead, Director Kazakovich.
Thank you. The deadline's October 21st, so we could deal with it on October 6th. I could put forward a notice of motion right now that the board provide their support for the grant opportunities that the volunteer fire departments will be applying for, and that's through the UBCM funding stream to build resiliency of volunteer and composite fire departments in preparing for and responding to emergencies through the purchase of new or replacement equipment and to facilitate the delivery of training. So I did connect with Chief Smith about this, and he is under the impression that we will be getting something for all of the fire departments that are part of this group. So I believe, I'm not sure if Tulameen is involved in that or not. So it'd be something to look into, but I'll just do that as a notice of motion and we can deal with it on October 6th.
Okay, thank you for that. Any other notices of motion? I'm seeing no hands. Don't think I'm missing anybody. Board members' verbal updates. Anything to report from the board members? Director Obrick.
Yes, thank you to the chair. And further to the award, just an update on the water utilities in the Vintage Views and Lakeshore Highland areas. Those are private. I've reported to this board in the last 4 years many times of community concern. Our community has had concern for a long time on this issue. I can report that the owner of the utility is supportive of 3 objectives: conversion, compliance, and getting that stop order on our planning department resolved. We've got 17 and more title holders, but 17 right now impacted with permits that cannot flow. This means jobs aren't happening, but worse, damages of thousands of dollars per month per title holder, plus delays in contracts. I've mentioned it before, people calling me, profanity, crying, it's hard. I gave the CAO an update on Wednesday, April 27, when I was at SILG. I've spoken to the MLAs. Rolly Russell was out on Friday, September 9, meeting in community. Dan Ashton was out September 2nd, meeting with community. This has my support. It's got the utility owner support. The community is engaged. They're working now on, they're going door to door. I'm hearing reports of 70, 80 or more % support. Remember, the Okanagan Falls irrigation district conversion vote was 92.5% support. This is going to have overwhelming support. It's eligible for grants once we get conversion. We have, if the front page of the Herald is a reliable source of information, Ministry of Environment is saying we're on the edge of catastrophic potential failure. This is not a good one. I've been speaking about it for 3-4 years. Now we're getting into the really serious stuff. So I will keep this board updated. There will be more coming in the future, but I just want everybody to know it's happening, and it's going to be another opportunity. When we did the Okanagan Falls Irrigation District conversion, we had a $48,000 cost for independent engineers. Lisa Bloomfield was wonderful. There's a $30,000 grant that only came on success. We're getting that $30,000 back. We can repurpose it over on the same program over to this purpose. All of this is happening, and I think the board just deserves the respect of that update. Thank you.
Thank you, Director Obrick. I forgot to click the mic on. Any other updates? I don't believe I'm seeing any hands. Wave if I missed anybody. That doesn't appear so. So looking for a motion to adjourn today. Moved, seconded. Thank you. All in favor? Any opposed? Motion carries. Thank you, everybody, for your patience and attendance.